Utilizing Utah Rules of Civil Procedure Rule 68 in Utah divorce and child custody disputes. Most settlement offers in divorce cases are easy to ignore. They're informal, flexible, and carry no real consequences. But Rule 68 of the Utah Rules of Civil Procedure is different. It forces a risk calculation. If you make what's known as a Rule 68 offer and the other side rejects it and then fails to do better than that at trial, the financial consequences shift, not just in theory, in real dollars. Here's the core idea. Rule 68 reallocates risks after the offer is made, and the other side has to ask, is trial actually worth it? If they guess wrong, they don't just lose, they lose more. They can't recover their post-offer costs, and they may have to pay yours. But there's a catch. Rule 68 doesn't automatically shift attorney's fees. Costs and fees are not the same thing. Costs are things like filing fees, transcripts, and service expenses. Fees are what you pay your lawyer. Rule 68 reliably shifts costs. Fees only shift if there's an independent legal basis, generally. And the comparison isn't just the raw judgment. Courts look at an adjusted award under Rule 68, the judgment plus pre-offer costs and any recoverable pre-offer fees. If that number doesn't beat the offer, the consequences kick in. That's where Rule 68 gets its teeth. But here's the problem. Divorce cases aren't clean math. Custody, parent time, and discretionary decisions don't fit neatly into a dollars and cents comparison. That creates an apples to oranges problem with Rule 68 to some extent. If your offer is vague or overly complex, the court may not be able to apply the rule at all. So discipline matters. A good Rule 68 offer looks like a credible prediction of a likely outcome, not a pressure tactic. It's anchored to something concrete, a statutory schedule, a prior order, a defensible support number. Timing matters too. Too early and it lacks credibility, generally. Too late and the leverage is gone, generally. The sweet spot is after discovery, in most cases, when both sides know enough to evaluate risk, but before trial costs explode. Used correctly, Rule 68 isn't just a settlement tool. It's a forcing mechanism, if you will. It turns abstract positions into concrete consequences, and it separates the parties who are evaluating risk from the ones who are just hoping for a better outcome.